Well,
he has to be sure that that justice will be done,
yes,
rather than the other way around.
My lady?
I'm trying to...
Yes, I'm bound to accept that. I maybe there were too many double negatives in what I was saying. I accept he has to...
Alright, yes, so welcome again, viewers and subscribers, morning, evening, night, whenever you check in as usual. Yeah, man, you're tuned to Ryan Media TV. If it's the first to tune to this channel, please click the subscribe link, click the bell to be notified for any brand new video. And if you're tuning in, man, just please like this video, because you don't know it, go always update on upon Wagwan. And Vybz Kartel, Jaja. Look like Vybz Kartel come on road, you know, viewers and subscribers. Yeah, man. I was taking in the second half of the Privy Council. I didn't know, say, yo, the first half did gone already. But remember, say, yo, we in England time. Different, you see me? Yeah, but taking in the second half, trust me, it look good from Vybz Kartel side. You see me? Yeah, man, because from morning, as them that say, Vybz Kartel didn't get a fair trial. And it look like basically a them thing there cause all of the foolishness right now where, trust me, it look like Vybz Kartel are gonna get a retrial. If not a retrial, they don't know him have to go come road. I just write this say the viewers and subscribers, yeah, man. But what me I go do still, me I go share the party of the video where me I tell you say, yo, the Lord and the lady them. Yeah, man, so them call them really a question the prosecution team, you see me? And the appeal where they go on and them say, yo, the jury, yeah, man, it was a big buffer. You see me? Yeah, man, them should have either suspend the juror there or from them know said them have a bad juror. Them should have at least do something about it. Basically, that me I get. But what me I go do, just I go share the video we doing right now, and you can take it in. So stay tuned.
Well,
he has to be sure that that justice will be done,
yes,
rather than the other way around.
My lady?
I'm trying to...
Yes, I'm bound to accept that. I maybe there were too many double negatives in what I was saying. I accept he has to satisfy himself that he is in a position, given what he's already said and will say, to ensure that there will be a fair trial for the other appellants.
Yeah.
That's the question. And in my submission, it's a question of fact to an extent, but on the facts, I submit he was entitled to come to the conclusion that the 10 jurors, with proper directions, would not take into account the fact that one of them had been offering bribes. And that, in my submission, was obviously a matter for the trial judge himself to assess, and that's how he assessed it. And my lords, my lady, I also rely on the fact that the Court of Appeal upheld the judge's judgment on this point. So what you would be effectively doing is saying to the, as were the local courts, they were wrong to hold that justice, there could be a fair trial, notwithstanding.
But the Court of Appeal appears to have been comforted by the fact that there was nothing to be gained by questioning or looking into the matter any further. At best, a denial of bribery, and a great deal that would have been lost, the possibility of having to discharge the whole jury. Was that the right approach?
Well, my lady, I think one has to bear in mind what was being put to the Court of Appeal. I think from recollection, what was being said to the Court of Appeal, and is not so much being said now, is that the judge should have carried out an inquiry. He should have made more inquiries. My answer to that is that if the judge was satisfied that a direction would put the matter right, then he was entitled to take that course. I agree. The question is, could he rationally be satisfied? You might say if he couldn't rationally be satisfied, well, that's that. But in my submission, he could be, for the reasons I've already, in a sense, gone through right at the beginning. He has reminded the jury of the seriousness of their role and the importance of deciding in accordance with the evidence. He's told them again and again, you are the judges, you are not to speak to anyone. They are well aware of their special position. And I submit it's quite often the case that prejudicial information comes out in the course of a trial, which gets in front of the jury, and as long as a judge's direction, I'll come on to the direction in a moment, as long as a judge's direction is sufficient to ensure that the jury will decide in accordance with the evidence, and not in accordance with the unfair prejudicial material, then he's entitled to take that course. And my lords, my lady, obviously one can well understand, of course, the concern in this case. Of course, that it might be said, well, who could forget? But my lady, my lords, I submit it's not that difficult. Jurors have to be trusted to act in accordance with their oath. I want to take you to a case about that. It's a cardinal principle that jurors do act in accordance with their oath, and they act only in accordance with the evidence. And if I may, can I take you back to the case of Bonnet, where Lord Hope makes this point, and he refers to other cases of higher authority, which say the cardinal principle of jury trial is that jurors act in accordance with their oath. They're not nincompoops.
Can I just ask you, in the context of your submissions, do you see any role for the Porter and McGill test?
It's fair to say that the way I'm putting it is that the question is whether there was a fair trial or not. And in my submission, if one could be satisfied that there was a fair trial, that is that. I mean, in one sense, I accept that what I'm saying is that if the court is satisfied there was no risk of well, in one sense, Porter and McGill is to do with a real risk of possibility that the tribunal is biased. But it's not the appearance so much, but there is a risk of possible bias. And to that extent, I accept Porter and McGill is right, because in my submission, what the judge did was to remove any risk of possible bias. It's not quite the same way as the Putnam test, but it comes to much the same. But appearance of bias per se, I submit, is not the relevant test. The question is, was there a real risk of possibility of bias?
And you say he removed that by the direction he gave at 3:22?
And also by what he'd been telling them before. It's the whole thing has to be looked at. It's often said in the cases that the judge is entitled to look at, the judge, in making these sorts of decisions, will bear in mind his view of the jury, so far as he can tell, over the course of the hearing. And in my submission, he was entitled to take into account also what the forewoman had said to him. And I do submit, if one asks, and looking at everything, if one looks at A, the verdict, B, the letting off of Shane Williams, and C, the evidence, which I'll come to later if I may, which is simply overwhelming, one asks, what unconscious bias, so to speak, added to all the evidence which was there anyway? How could it have done? And that is the point about the strength of the case. One can see where the evidence is equivocal and so forth. One might say, well, that's rather harder to tell. But if it's 2 and 2 equals 4, well, there is in my submission a basis for saying the risk of a possibility of bias it has been removed, was not likely to have affected the jury's verdict, or won't have affected the jury's verdict. Can I just take you to the Bonnet and Taylor case, because it is important.
You say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. It's the same, is it?
No. No, my lords, it wouldn't be the same. If I may, no. The important point here is the prosecution knows the problem, and in the passage I took you to, the prosecution says, we're the ones taking the risk.
Well, but they can't waive the public interest in the administration of justice. It's not a matter...
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
You're really just postponing the question. So, on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting to me, saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then, boom, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and 1 bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. And the jury has, if it's going to acquit, is going to have to do it by, is it an 11-person jury is going to have to do it by a 10-1 majority? And how does the court, the judge know? Well, it's likely that there will be 9 good people and true and 1 crook in the 10. It's an acquittal.
Well, my lord, if in my submission the judge, the fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point: can the prosecution say, I know there is this one person who seems to be offering bribes, we probably can't trust him, but I'm prepared to carry on and take that risk. Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may with great respect say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied, the 10 were not influenced. I agree, obviously, that's the separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. I do firmly say that would bring justice into disrepute. 10 people have done their duty, 1 person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the 1 has brought disaster? That brings the jury system into disrepute. Our learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point about who knows what was going on in the back of the jurors' minds. That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And it would
Can I just take you to, where we got to, I think, which was paragraph 25 of the Bonnet-Taylor decision, page
Yes.
6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
You know, don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context, it does, because they will all know there's been this half-hour break in the summing up, while form has been called away. She will have told them, because the judge says, tell the others. She will have told them what's happened. And, my lords, I fully accept, of course, one might say the direction could be more forceful. I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission, it was.
But all I'm saying to you, putting to you, is that what was said by Lord Hope hardly supports your case, because this was not a specific direction.
Well, my lord, not express. I don't want to, as it were, quibble. I accept it was not specific, and of course it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission it was sufficient.
Could be. I'm not sure that it. I think you probably have dealt with this point, but it strikes me. But when you say this is a question of common law, I don't think it's purely common law, because we do have the statutory provision.
Yes.
It's on page 6803.
Yes.
Which tells us that 12 jurors form the array in a case of murder, and then says in subsection 3, where in the course of a trial any member of a jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members, so it's a proviso, so long as the number of its members are not reduced by more than one, be considered as remaining properly constituted. Now, it might be said that the judge, as it were, can't sidestep that provision by failing to discharge somebody where there was indeed sufficient cause to discharge them. If he discovered, for example, that the person, the person had been bribed, or was the defendant's brother-in-law, or whatever you like.
Well, in my submission, that wouldn't be the correct construction of this. In one sense, you have my point. As long as there are.
I mean, you were saying it's just a question of counting the number of live bodies on the jury, and that's
all it's saying.
Yeah.
Well, my learned friends, my submission, that's what it's saying.
Yeah.
Yes. And my lord, after all, one doesn't know. I mean, at the time the judge gives his direction and decides what to do, he might be hoping against hope, so to speak, that the miscreant juror will actually just see sense. But it doesn't follow in my submission from this act that the judge is bound to get rid of that juror. That's the question. But I agree, if he's bound to get rid of that juror, he's bound to bring the case to an end for that very reason. And this is why it is a short point, but in my submission a difficult and interesting point. I haven't addressed you on the proviso and things like that, but I'm conscious of the time. But I wouldn't mind showing you some of the evidence. I mean, it is, because I do connect it to my point. Well, there was no need for any, if I can put it this way. Anyone looking at the evidence would say, I couldn't care less about these bribes, so what? I've seen it with my own two eyes, type of thing. Forget the bribe.
Yes.
But I'm conscious, my lord, I'm preying on your time. I don't know how you want to proceed. I see what the time is now.
Well, obviously you have more time tomorrow. We perhaps, speaking for myself, the point you've made about how you could find out after the event that a juror was corrupt. And the question then is if the other jurors had voted 10-1 to convict, completely ignorant of the fact that would the verdict nevertheless be vitiated, and it would have to. And I think if it were, it would be on the basis that we've been discussing, that there is, as it were, a non-quorate
non-quorate point, really, yeah.
Which suggests it may suggest that the point we made earlier, the point I made earlier about based on. Seraphim may not be quite as obvious where you have 11 judges, as it were, as it is where you've got one judge.
As in that case.
Well, shall we leave it there for the...
I'm so sorry. Yes. The case that you mentioned in Strasbourg about the racist members of the jury, do you have the reference?
Mr. Turnbull has the reference. It's Gregory v UK, page 7914. And I have a feeling there are two other cases which similar issues arose. I cannot quite remember. If you give me one sorry.
Alright, so we reached the end of this video. Yeah, man, me just take out a look apart. I'm not doing everything, but if you don't want to check out the full video, you can check Guyana Uncut. Yeah, man, them have the full first and second half. So if you haven't subscribed as yet, click the subscribe link, click the bell, and you can share this video as well. Yeah, man. Follow me on the IG as well, RyanmediaTv.